There I am. Good evening, everybody. This is Jonathan. I hope everybody's doing well. And welcome to my live stream. Today is August 14th of 2024. Hope everybody is staying cool. Here in Atlanta, it is actually fairly reasonable. It's like in the low 80s. We've had it in the 90s, so I'm really happy about that. And I hope, again, everybody's doing well, and I'm looking forward to answering your questions. So we've got some questions that have already come in, and let me go ahead and start with those. Reverse mortgage videos says, can you explain how date last insured works? SSA says my DLI was September 2025. If it takes them a year after to prove my claim, will the DLI be a problem? No. Basically, what the DLI means, that it's almost like paying insurance premiums. So your DLI is the date when the insurance premiums basically run out. So as long as you're found disabled prior to that date, you are good to go. So there's no, it doesn't, if you're found disabled, 6 months after the date last insured, as long as your onset date is prior to the date last insured, you are good to go. So that is how that would work. So anyway, I hope that explains that. And it is not a problem at all. If your date last insured is after the date of your hearing, as long as, like I said, as long as the date last insured is before your onset date. Now, where you run into problems would be if the judge found you were disabled in October of 2025, then it would be after your date last insured. But a lot of times, if you think about it, for the most part, you've got to show that you have worked for 5 out of the last 10 years. So if you stop working, your insured status will follow you for about 5 years thereafter. So if you stop working in 2020, your date last insured will be in 2025. Somebody applies for benefits in 23, it may be after the date last insured for a hearing. I have a lot of cases where my date last insured is, let's say, December of 23, October of 23. Not a problem. Now, if it starts to get like with the date last insured is 2021, I'm going to be a little more careful because that's trying to show that my client became disabled 3 and 4 years ago. That's more difficult. But if it's within a year, it's usually not a problem. Okay, Christina, hello from California. Rodney, hello, how are you doing? G.I. Jose, his phone hearing lasted 45 minutes. Does a law clerk or judge read all the evidence and file? Felt like no one did, or are they testing me? Generally speaking, the judge will look at your case beforehand and they'll look at your case after. And so as a rule, the hearings don't take very long. Some people say they're kind of a waste of time, but the judge is going to look at all the evidence. That's, by the way, why I typically do a pre-hearing brief where I can set my argument out. But the medical evidence is a lot more important than your testimony. The judge already theoretically knows what's going on, knows the facts, the date of onset, the date last insured, the medical problems, and typically your attorney would just ask you a few questions just to enhance your credibility. But it is not a problem at all if the hearing only lasts 45 minutes. That's typically what they last. Okay. We have Justin Yu has scheduled a consultative examination in September, checked on the psych doctor, only one review. It's not positive. How to prepare. Again, a lot of the consultative doctors do this to make a little bit of extra money. My experience has been that consultative psych doctors usually will give you kind of a fair assessment. Most of these people are practicing psychologists. They are, used to finding medical or mental health issues. Where you run into trouble would be the physical medicine doctors. They typically are, working insurance company. They work for insurance companies to deny claims. So, a lack of review is not a huge deal. I still say if you've got your own treating doctor, that's a lot better than relying on a consultative. You're generally not going to win if all you have is consultative doctors. But, my experience has been that the psych consults will give you something to work with or give the attorney something to work with. But, it's not going to win or lose your case. Obviously, unless the doctor says that you're malingering or have secondary gain. But assuming that's not the case, then that wouldn't be it. Now, if you want to protect yourself a little bit, if you have ongoing mental health treatment records, bring them with you or give them to the doctor ahead of time. I find that doctors in a consultative capacity are less likely to go against the findings of a doctor who has treated you for a long period of time. Okay. Used the non-exertional limitations from the article. Vocational witnesses unable to maintain employment. Fingers crossed. Yeah, that's what you want to focus on, is the impairments, both exertional, which are physical, sitting, standing, walking, lifting, carrying, bending, stooping, kneeling, crouching, crawling, and the non-exertional, pain, fatigue, restroom breaks, nausea, things like that. So you want to put both in there. In a grid rule case, you've got to have mainly exertional limitations, but the non-exertional limitations can help you get rid of transferable skills, because any capacity you have to transfer your skills would be reduced or eroded by chronic pain or fatigue or medication side effects, drowsiness, things like that. Kay Wolf, thank you for taking the time to share with us on the ALJ level. Is it my responsibility to get files to someone at the ALJ? Typically, your representative will do that. You shouldn't be doing that. One point I do want to make is that at the ALJ level, you as the claimant or your attorney have the responsibility for updating the records. At the initial and recon, Social Security does that. Now, your attorney will help by letting the Social Security know about other records that exist, but at the hearing level, the person who needs to actually upload the records and do it electronically, ideally, would be the attorney. If you're not represented, you got to do it yourself. That's why, one of the reasons I always tell people don't represent yourself at a hearing is you probably are not going to know, that you have to update the records or how to do it, and make sure and confirm that they're there. So that's one of the things an attorney really can do for you. How do you look at your Social Security file to make sure it's correct and what they need? Your attorney can give you a download. Most attorneys use services like there's one called Assure, there's one called Chronicle, there's a couple other ones out there where it will go to the ERE, Electronic Records Express, download all the files into one searchable PDF, and then you've got the whole file there. It's one PDF file that's searchable. I always tell my clients, you want a copy of it, I'll give you the whole thing. That way it's your file, you should keep that. So you can ask your attorney to download your file from ERE, which is the individual records, 1A, 1B, 17F, all those, or you can get it in one big file that's searchable. That's a much better way to do it. So ask your lawyer if they use Assure or one of these services that will consolidate the records. And literally, these services, they cost like $5 or $6 a case. So it's very, very low cost, and you get a lot of benefit out of it. One of my uses called Chronicle, and I've talked to the guy who developed it, and, I've made some suggestions. He's very responsive. He'll put the judge approval rate in there. He's got a copy of the DOT in there. He's got a lot of stuff in there. And again, when you download it, it's just really, really helpful. It's really nice. So that would be something that would be very helpful. Okay. And somebody says, do you have a lawyer? If not, you'll have to send it. I think K. Wolf does have a lawyer, but, again, when you get whether you have a lawyer or not, you should always try to get a copy of the file, because you want to make sure that you are aware of everything in your record and you look at it. Thank you, G.I. Jose, for the review. I really appreciate that. I'm going to put a little banner up here of how to do that. I've really gotten some nice reviews, and I really appreciate that very much. So if you would, please do that, because it really helps me grow my practice, and I'm really grateful for doing it. So that would be really appreciated. Okay, John, I'm 63 at Recon, have an SCE that says sedentary work, no stooping or crouching. My doctor completed an MSS or medical source statement, says I can only sit or stand for 20 minutes, need a 15-minute break. Good case, yes, good case, because at 63, you would fall into the light grid. And what I mean by that is that the grid rules, in fact, let me pull them up here so you can see them, and we'll kind of analyze this together. Let me just go over here and pull this up, gridrules.net, and I'm going to show you how this works. Present, share screen. Okay, so here is the grid rule, my website called gridrules.net. And so if you look at light, and light, remember, is standing and walking up to 6 hours in an 8-hour day, lifting 10 pounds frequently, 20 pounds on occasion. And John basically says that he can't do that. He's at sedentary work, which is less than that, which is standing and walking 2 hours. So he's already there. But let's say that he's limited to light work at 63. So he's over 55. assuming he has no transferable skills, at 55 plus, he is disabled. Plus, there's something called the POMS, P-O-M-S. There's a section there that says that if you're over 60 and limited to light, a judge would have to find that if you got another job, it would be a minimal vocational adjustment, which basically means you would be doing the same thing you were doing before. So here we have a guy who is 63. He's limited to sedentary. If we look at sedentary, he's 55 plus, limited to sedentary work. Again, same sort of thing. High school grad or more, no direct entry into skilled work, no transferable skills. He is disabled at 201.06. So I would argue to the judge, this person meets grid rule 201.06 because he is a high school grad. He does not have the capacity to go right into skilled work because of his pain. His other things, he's limited to sedentary by an FCE and medical source statement. And because of pain, medication side effects, nausea, bathroom issues, whatever it may be, his skills are not transferable. Therefore, he is disabled. And I literally had a case today where I made that argument, and it was an unusual case because the person had gone to a previous hearing, but in this particular case, at the previous case, the look back on work was 15 years. Now it's 5 years. So I did a pre-hearing brief. I said, look, Judge, the look back is 5 years. The person has not worked at SGA level in 5 years. Therefore, there's no past work. The person is over 55. Therefore, unskilled or no work. She had a 10th grade education, limited or less, boom, boom, boom. 201.01. This person is disabled. I get a call about 10 minutes before the hearing from the judge. You were right. We're not going to have a hearing. You won. So, the grid rule is really, really powerful ways to make this work. So that's how the grid rules work. You're helping expert. Well, thank you, John. I appreciate that. That is very nice of you to say. And I believe in sharing what I know. This is not brain surgery, but it's not easy either. In fact, I was working today on, and I'll get it out on my website and I'll have it next week. I'll put it out there. I'm writing a little article about working after being approved for disability or working after your onset date. And as I'm going through it, I'm realizing it's complicated. There's a lot of rules, a lot of exceptions. It is not easy. You've got trial work period, you've got SGA, you've got situations where, you have a trial work period before you're found disabled. You can, what does that mean? And then SGA, or trial work period, it's 9 trial work period months in a rolling 5-year period of time. How does that work? When do you find out? SGA, what happens if you go over use up your trial work period and you go over SGA and you got to look at it every year? It is ridiculously confusing. And the big problem is there's no real-time place that you can go on the Social Security's website to say, yes, you are over, you've used a trial work period months or you're over SGA. There's just no way to know. So, I literally had somebody call me. This is actually a friend of the family. A guy calls me and says, I just got a letter from Social Security saying I owe them $20,000. Can you look at it? So I looked, and lo and behold, he had used up his trial work period. He was over SGA by very, very little. And again, SGA in 2024 is $1,550. He was over it like $1,600. He was over by $500, let's say, maybe $50. But once he go over it, every month he's over SJ, he's an overpayment. So he literally racked up $20,000. They notified him 2 years later, 2.5 years later. So I'm like, there's really nothing you can do. You can appeal it. You can ask for an abatement, but they're probably not going to give it to you. You just got to file bankruptcy on it. That's really the only way to do it. So my point is that it's very, very complicated. So, part of the reason I do this is to share what I know, because it is complicated. And, look, some of these things take me a while to figure it out. I'm dealing with this stuff every day. I've been doing it for 30 years, but it is definitely complicated. What is the best thing you can do to make sure you're ready for the ALJ? Okay, I would say a couple of things, K. Wolf. Number one is, do your research. I've got a lot of videos out there about how to prepare for your hearing. So go to my YouTube channel. SSA, it's SSD, Ginsberg SSD is the thing, or I think it's at SSD Attorney, something like that. Just put my name into YouTube. So that's one thing you can do, a lot of videos there. The second thing I think is really important to do is to understand what the issue is in a disability case. And the issue in a disability case is your capacity for work. A lot of people get very focused on their medical problem. And while their medical problem is important, it is not the main issue. The main issue is your capacity for work. So you definitely want to be really focused on your capacity for work and anything that would prevent you from working. So, medical problem, you have diabetes, that is not going to disable you, but if you have to use the restroom every 45 minutes, that can be a disabling impairment. If you have to go to the restroom to inject insulin and you're in the restroom for 7 minutes every 2 hours, that is a work limitation. If you have low blood sugar, where you basically pass out 3 times a week and you're out for 45 minutes, that is a work problem. If you have a herniated disc, doesn't mean you're disabled, but if you have a herniated disc and you can only sit for 15 or 20 minutes and 2 hours total during the course of a day and stand for 10 minutes and 2 hours total in the course of a day, those are work limitations. So really think about your medical problems and think about the very specific work limitations that apply. Number 3 is when you talk about your limitations, be specific. Eliminate from your vocabulary, not very much, not too far, not a lot, just a little, hardly at all. I just piddle around. You got to be specific. I can sit, I can stand for 10 minutes, for 15 minutes. I can stand for 2 hours total during the course of a day. I cannot reach overhead, over shoulder level. I have to keep my leg extended over waist level. You have to be very specific and you have to talk about time frames, distances. I can walk 2 city blocks and I've got to stop. I have to use a cane to walk, a prescribed cane to walk. So I think that is really important to be very, very specific. I think you want to make sure that your record is updated, and your attorney should be doing that to make sure that there's everything up until, say, 2 or 3 months ago. If there's any sort of reference to drug-seeking behavior, malingering, use of marijuana, you got to be prepared to deal with that. You may say the doctor was wrong, or I was doing that and I went through treatment and I'm not doing that anymore. But you need to know where the danger signs are in your case. At the end of the day, the best cases are ones where there is objective evidence. So if you have a situation where it's a pain case, back, knees, shoulder, ankles, elbows, things like that, you need to have MRIs, CTs, X-rays. Don't go in there, my back hurts, but we don't really know why. That's not going to help you. So if you have to spend $400 or $500 to get an MRI, you got to do that. And that's something that can be very, very important in a disability case. I think those are the things that I would say are just really important to do. Practice with your attorney how you testify, how you answer those questions. Don't ramble. The judge is looking at you and saying, okay, you stopped working in April of 2023. He doesn't care what happened when you were a teenager. You fell out of a truck. You can maybe mention it very briefly. I've got a long history of back problems going back to when I was a teenager, but they don't need to hear your history because, again, you are, assumed that you are not disabled as long as you're working. So up until the date you stopped working, it's assumed that you had the capacity for work. So that is, those are the things you want to be very, very specific. Look at the file, know the file. The judge will ask you about your past work, know what you did, know the dates of your past work, know your medical the medicines you're taking and the side effects of the medications. And I think the final thing I'll tell you is go in with the attitude that you are fighting this every step of the way. You hate the idea of being disabled. You hate the idea of having to go through disability. You'd go back to work tomorrow if you could, but you can't. You see it as a temporary thing, and you are fighting it every step of the way. Do not go in with the idea, oh, I'm disabled, I know, pay me. Don't want to do that. I've heard cases, I've listened to audios of cases, other people have me listen to their case, for a possible appeal, and you can sort of tell that the claimant is very invested in the idea of being disabled. You do not want to do that. Don't want to do that. Okay, I hope that gives you some things to think about. And again, look at my videos. They'll give you some more guidance there. Do I take long-term disability cases? I have taken them. I usually, there's a couple of attorneys, one in particular, that I work with on long-term disability cases. So if you've got one, please let me know. And if I can't do it, I'll hook you up with somebody who can, or I'll joint venture with him. It's a gentleman that I'm actually going to be doing more formal joint venturing with coming up toward the end of this year, I believe. So, if you've got one, please let me know, and I'm happy to put you on the right track. because of those cases, I've done them, and they're very similar to disability. And if I had more time, and maybe I will start doing more of them, but right now I can do them working with somebody else. Okay, but I'm still involved in it. All right, Cancer Free, who's been here before. When I went through breast cancer in 24, I was married. They told me they couldn't give me benefits because I was married, not homeless. So I have to be divorced and homeless before they give you benefits. All right, so I'm assuming that you were applying for SSI, and realize that SSI is a means-tested program. It's when you don't have enough credits for SSDI. If you're married and your spouse is working, then his income or her income is what they call deemed, D-E-E-M-E-D, deemed to you. Therefore, his income would count against you as far as your disability. So you may be found disabled medically, but because of household income, and the limits are really, really low. They haven't changed these for SSI in years. It's really ridiculous. It needs to be, I think it's $2,000 in assets, and in terms of income, very, very low income. So, if you're applying for SSI only and you no longer have, support from a spouse, then you could pursue it. But, the issue with SSI, you got to be real, real careful about those income and resource limits. It's hard to get an attorney for an SSI case because, usually there's an offset and there's not a lot of past due benefits. So it's hard to take them. But I think that would be something to ask. Go to ssa.gov/myaccount, download your My Social Security statement, and then you can see if you're insured for disability benefits. Let me also tell you that if your ex-spouse is deceased, there are situations where you can use a divorced ex-spouse or deceased ex-spouse and go under his or her earnings record if you don't have one of your own. So I think first thing is to find out whether you have enough credits. And if you don't, is there a way around it? Trish Wade. Hello, Trish Wade. How are you doing? Jerry, my wife got SSI. No, she can't find a pain management to go to because they changed her insurance to Anthem. She had hip insurance, I'm guessing. Okay, again, SSI gives you access to Medicaid. SSDI gives you access to Medicare. So again, depending on what you're talking, people sometimes call, by the way, Social Security disability, they call it SSI. It's like calling, a Kleenex or a tissue that you blow your nose with, a Kleenex, or a copy machine, a Xerox. SSI is a type of disability, but there's other types, SSDI, SSI. So when you're talking about SSI, that's the means-tested one where you don't get it if you have a spouse who's working. So if it's SSI, then she would get Medicaid. SSDI, she gets Medicare. And again, the Medicare could be an issue if you don't have the right kind of insurance. That's by the way I've talked to you about my friend Cal Hero, and he's got a website called Medicare Mall. If you want to check him out, and call him if you have questions about the different types of insurance that you can use under Medicare through Social Security. Cal's a really sharp guy, and he's been very helpful to my clients. Okay, do I have to be divorced and homeless before they help? Again, as we were talking about, if you are going for SSI, it sounds crazy to be divorced and homeless. Yeah, I mean, you got to really have very little, almost nothing. It's pretty bad. Suki, what is the maximum my future husband can make so I can still keep my Medicaid on my SSI? There is I don't have that off the top of my head. I don't deal with a lot of SSI cases. If you just type in income and resource limits for SSI, it will tell you. But that's how you'd find out. And I'm not going to do it right now, but just go to Google and type in income and resource limits for SSI, and it will tell you. Rodney says, hello. Hello, Rodney. How are you doing? I hope well. Zippy, I got a BK 820 asking about work before being approved. I'm an SSI for 2 years. Should I be okay? Well, I think what they're asking for is, do you have any work that might be over SGA or substantial gainful activity level? And that is one of the forms they use to look at your work. So you've got to keep pretty good records as to what you're doing. And again, if you're over SGA and you're on disability, or if you're over trial work period, you have 9 of those months. If you use up your trial work period months, then they look at SGA. So you want to keep real track of that. And when you keep track of it, by the way, you want to look at your earnings, the income you get based on the month you receive your paycheck, not the month you did the work. So if you worked in July and got paid in August, that counts towards August. So literally create a spreadsheet, whether it's on the computer or on a piece of paper, the month, gross income received, expenses that were necessary to allow me to work, and reduce it by that. That's all you really need to do, and really month by month. And if you're seeing it's going over 2024, 1550 a month, then you potentially have a problem. And again, that's really where you got to just do your own research. Talk to lawyers, do your own due diligence, but you got to be real careful about that. And I think people get set up by Social Security. It's a real problem when they get overpaid and they don't realize it for 2 or 3 years. Luca Brasi from the Godfather. He is 59 and on SSI. All doctor's appointments, medication are free of charge. Will that change once you hit retirement age? Well, once you hit retirement age, you should go to full retirement disability. I think you'll beginning to get Medicare. So the question there would be, can you get a Medicare plan that will cover your medications and your doctors? And that's, again, where somebody like Cal Hero at Medicare Mall can answer those questions. I'm not a Medicare, Medicaid person, but that's what somebody like Cal would do. There's other people who do it as well, but I trust him, and he's been very good to my clients. So reach out to him at medicaremall.com, and he'll be able to tell you how that works. David John, I was approved for SSDI and started getting it in April 23 when I'm in a mental hospital. I started part-time in January of 24. Do I need to call every disability? No, I don't think you need to. I think that they'll get that information when you file your taxes or when your employer reports it. I think what you have to be taking really a close look at is keep a list of your gross earnings every single month. And if you're over the trial work period, you have 9 of those, like I said, and look, I'll have an article about this on my website coming up during the week, but you have trial work periods, $1,110 is the amount. You have 9 of those. So as long as you're under $1,110, no problem. If you have 9, $1,110 or more, then you get into that between $1,110 and $1,550, which is SGA. If you're below $1,550, you're fine. If you start getting over $1,550 on a regular basis, you potentially have a problem. And that's where you just got to really watch that. And like I said, I wish there was some place you could go at SSA.gov to track it. There just isn't. If I can get around to, if I can find the time, I'll maybe put together like a sample spreadsheet that people can use. They can just write it in where they can kind of keep track of it. But it gets a lot of people, it catches them. And this is where Social Security, I think, has really dropped the ball in helping people understand the rules about this. Muley says, that's a D. I wasn't sure what that was. It looks like it's an elk or something, or a moose. My case is the 8-month time frame. I just got a letter for an exam. I thought I had more than enough medical records to back up my claim. Should I be worried? So Muley has gotten a letter for a consultative evaluation. I will tell you that is pretty common. I would say 80, 85, 90% of disability claims, Social Security sends you out for a consultative evaluation. They just kind of do it. Every once in a while you see one that doesn't have it. It is not a negative. It's just something that they're going to do. Technically, a judge can deny a claim based on the consultative evaluation report. Practically, they don't really do it. Now, I looked at an appeal from a gentleman who asked me to look at it yesterday, and we had a judge who did exactly that. The treating doctor's records were very supportive. The judge basically says, I don't find these persuasive. I'm going to rely on the consultative examination. I'm going to rely on the non-treating doctors of the state agency who just looked at the case. And she denied him, and he's not real happy about it. Needless to say, we're looking at it for possible appeal, but they can do that. Judges can do that. So, but to answer your question, Yuli, it is not a problem to have a consultative evaluation. Todd, thank you for going live. My pleasure. Should I get a lawyer before I apply? I'm bipolar. I'm under treatment for years. SSD and SSI, confused word again. Okay. You don't necessarily need a lawyer to apply. You can go to ssa.gov/apply for disability. Sometimes people want a lawyer just because they don't want to deal with the hassle of it. What I would do is go to ssa.gov/myaccount, ssa.gov/myaccount. Let me just put that in the comments, ssa.gov/myaccount. And what you want to do is get your My Social Security statement. That will tell you if you have enough credits for Title II SSDI. If you do, then obviously when you apply, you want to apply for disability. SSI is a means tested program. So if you have very low income, you have no spouse, you have no means of support, you have less than $2,000 in the bank, you could apply for SSI. But if you have more than $2,000 in the bank, if you've got other support, families helping you, then you may not want to. Usually an SSDI typically offsets SSI. So that's, again, if you talk to an attorney, that's something you could talk to about with your attorney, but choosing whether to do it. Big picture, SSDI is a more robust program. There's no offsets for assets, things like that. So if you qualify for SSDI, apply for SSDI. You can also apply for both. And if you don't qualify for SSI, they'll just knock you out administratively. So if you're not sure what to do, just apply for both. But you want to see, have you worked in the last 5 years? If you have, more likely than not, you're qualified for SSDI. But I would look at your My Social Security statement to see, and then apply. And if you want to get an attorney to help you do it, if you're not sure about what to say, then there's nothing wrong with doing that. I realize attorneys get paid. We get paid 25% of past due benefits. So I have people that hire me. I file an application. I help with the forms, answer questions. And then if we win an initial, then I will generate several $1,000s as a fee. Most people have no problem with that because I'm providing value. Some people are like, why should I pay you? You're only doing the case for 6 or 7 months. Well, again, my answer to that is it's not how much time I put, it's knowing what to say. It's knowing how to put the application together. It's knowing how to answer the forms. It's knowing the arguments to make. But again, everybody's different. But I would tell you, you don't have to have an attorney. And I tell everybody I talk to who is at the initial stage and they say, should I hire you? I'm like, that's up to you. I'm happy to do it if you'd like me to. If you don't, no offense, call me if you get denied. I talked to 2 people this week who were who've already applied. And I said, why don't you just wait and see what happens? No. I want you to get involved. I want you to see what they've got. I want you to make sure that we get everything uploaded. I want to have somebody I can call to answer questions. So that's legitimate. So I realized, that's how we get paid, a percentage of past due benefits. Vincent, good evening. You'll be calling me on Tuesday the 20th. What time does your office open? Want to be your first phone call in the day? We open at 9 o'clock in the morning. If you would, actually, I'm going to be out of town. I'm going to do the live stream, but I'm going to be out of town on vacation next week. So I'm trying to limit my calls. So if you want to call me, send me an email and I'll send you a Calendly link. You can go to my calendar for the week after, because again, I will be taking phone calls. Office is going to be open, but I'm really trying to, I take 1 week a year of vacation. I just want to, enjoy my vacation. So I've got a hearing next week that I'm going to be doing, and I've got a couple of calls, but I'm trying to limit the calls. So if you wouldn't mind, if you want to talk to me, email me, and I'll get you on the calendar for the week after. I would appreciate that. Okay. Rolando. I was denied at a hearing level, 52, a diagnosis of fibromyalgia depression. You have a chance at appeals council, federal court. I will tell you, Rolando, I have never, and I mean never, had any success with fibromyalgia with a male. Fibromyalgia is a chronic pain condition. It is not something you can take an MRI or a CT or an X-ray of. It's something that has to be reported based on symptoms. Unfortunately, Rolando, I've never won a case, and I've tried several of them with a male with fibromyalgia. I think it is a really hard road to go. Depression, yes, depression cases. I think it really depends on what your doctors say about the severity of your symptoms, how long you've been treating, the type of treatment that you've had. Has it been successful or not? The best chance to win is at a hearing. Appeals council is kind of rubber stamp. Federal court's a little bit better. It's going to be an uphill battle. I just wish I could tell you differently, but it's going to be an uphill battle with depression and fibro, because those are, invisible illnesses, and those are really, really hard, unfortunately, with Social Security disability. Why couldn't you take my case? I'm paying workers' comp. Okay, I will answer that question for you. And I'm not going to talk about your case in particular, but generally speaking, if somebody reaches out to me and they are getting workers' compensation benefits, I will not take their case. And the reason for that is that workers' compensation offsets Social Security disability. So if you're getting workers' compensation, you're not going to be eligible for Social Security. So if somebody's getting ongoing benefits, every month they're getting ongoing workers' comp, they cannot get Social Security. I get paid on past due benefits. So if I take a case where somebody's getting ongoing workers' comp, there's no past due benefits. I can't get paid, so I can't take the case. It's just as simple as that. I can't take it under contingency, and that's the reason why. So it's one thing. It's just there's no way for me to get paid, and Social Security makes it so difficult for attorneys to do these cases any other way. I mean, theoretically, I could tell somebody, well, you can deposit, $3,000-4,000 in my trust account. Of course, nobody has that, but if you did, and I can work off of that, then I got to file a fee petition, which is a major pain in the rear end. So it's just really hard to do it that way. The second issue I will tell you is workers' comp and Social Security do not play well together. What I mean by that is that when you have a comp case, there is, obviously there is a medical component to it. There's a wage component to it, and workers' comp, part of the settlement when you settle your case is, it's supposed to be set aside to cover future medical care. Medicare, which is associated with Social Security disability, SSDI, does not want Medicaid, I guess, the same way. They do not want people who are on workers' comp to take their work injury, and instead of having the insurance company pay for it, they don't want Medicare to have to pay for it. So typically in a comp case, there will be something called a Medicare set aside. I was talking to somebody about this today. It means that part of your settlement in comp has to be set aside to cover future medical care. Further, many times you have to agree not to file for Social Security for 2 years or 3 years. So it gets real complicated. So I'm really reluctant to take a case that's active workers' comp because I can't get paid on it. And secondly, because I don't want to screw up somebody's workers' comp case. And usually when I talk to the comp lawyer, that person would agree with me that it's not wise to file for Social Security until after the comp case settles. And if you do settle your comp case, you want language in that settlement that says that this settlement is to be treated like it's over my expected lifespan. It's called a Hartman clause. I realize it's very complicated. I'm getting in the weeds on this, but that's the main reason is that there's no past due benefits, no way for me to get paid, and I can't work for free. How can I tell what medical records maybe SSDI has? Again, you can ask your attorney to download and send you a PDF, an Adobe PDF file of all the records in your file. That's how you know what they've got. Or they can get an ERE, if you're not at the hearing level, they can get Section F of your file. They can download that and send you a Section F report. That will show you exactly what they have. And I do that for people all the time. Lulu's after party. I stopped working in November of 23. I have bone and bone knee issues along with hernia, overweight. I'm at an appointment with SSDI doctor soon. Again, not SSI, is it SSDI, SSA? SSI is a specific type of thing. So don't call Social Security Disability SSI. 57, can't work as a caregiver. All right, so I'm thinking here that the grids might apply. You are 57, so even if you could do light work, standing and walking 6 out of 8 hours, probably can't do that, you meet the grid. So I think that, and the weight is going to also make it less likely to be able to do light work. I think you probably meet the grid. Therefore, I think you probably have a winning case. That's the way I would analyze that. Okay, Deb says, it depends on your state. Okay, so this is asking about the SSI. And Deb, you probably know more about it than me. I don't deal with the income and resource elements of SSI. Elder care lawyers actually do many times. And I think, they deal with child SSI cases and assets. And, there's certain kinds of trusts you can do. SSI rules about, there's one area of it, SSI, where people are trying to get into a nursing home. And so, when can you, transfer your assets, and how long does it have to be before you can, give them away and then claim you have no assets? It's a whole area of law. In terms of clawbacks for SSI purposes, it's way beyond what I do. Again, I'm focused on getting people on disability, but SSI generally is the area of what they call an elder care lawyer. And they usually deal with elderly people and children, but they're a lot more knowledgeable than SSI than I would be. Okay. Why did they send me to a CE? They were close to making decisions. The DDS scheduled me for. I'm 58, have stenosis and Parkinson's, severe depression, anxiety. DD, there is no other reason other than that they just do. I mean, it's just one of these things that Social Security adjudicators will just do it because it's just part of their daily activities. Send them out to a CE just to make sure that we can trust that, that the doctors that the person's getting treatment from are legit. To give you perspective on this, and maybe this is oversimplifying it, but just so you know, I'm going blurry there. There was a case a number of years ago, a gentleman, an attorney named Eric Conn, C-O-N-N, and you can look him up, Eric, E-R-I-C, Conn, C-O-N-N. And Mr. Conn had this, he was a criminal, and he had this whole scheme worked out where he had doctors and Social Security people and judges all getting paid. And so what would happen was he would file a case, he would send the person to the doctor that was on the take. The doctor would then write a report favorable. The judge in the case would get the case assigned to him, and he would approve it. And then Conn would make money. The judge would get a kickback. The doctors get a kickback. And so, you had this whole scheme going on. It cost Social Security several $1 million. They eventually caught him. They put him in home confinement, had an ankle brace. He cut it off, fled to South America. They eventually got him. He's in prison now. But as a result of this Conn case, and there's like a HBO special on it. You can look it up. Social Security goes overboard. And so they decide, well, we have this one guy that ripped us off. So therefore, we're just going to, decide that all doctors are potentially on the take. So they get rid of the treating source rule, which had been in effect for years and years. Treating source rule said that absent unusual circumstances, the opinion of a treating doctor will carry more weight or controlling weight as opposed to a consultative doctor or a one-time doctor or an insurance doctor or a CE doctor or a state agency doctor who never saw you at all. They get rid of that. So basically they're saying, well, we can let the judge approve or deny based on any medical record at all. You could have a doctor you've seen for 5 years, a world-renowned orthopedic specialist who's, worked on, famous athletes and celebrities, well respected, just renowned. Doesn't matter. We can deny your case because you went to some CE doctor in a mall who decided that you don't have anything wrong with you. Most judges aren't going to do that, but it does happen. Like I said, I had a case yesterday where it did happen. So I think that there's this residual, to answer Dee Dee's question, a residual distrust of the doctors that many people go to. That there's a thought that the doctors and the claimants are kind of in cahoots with one another, and that the doctors will say anything to help their patient. It's not true. I think that the Eric Conn case is a one-off, but again, it's a classic overreaction by Social Security to a really embarrassing situation. This went on for years, cost a bunch of money. Congress is outraged by it. There's 2020 and 60 Minutes are doing stories. It was a black eye for the agency. So what do? We want to make sure this never happens again. So we're just going to throw the baby out with the bathwater. We're going to change all the rules so treating doctors are no longer given any controlling weight. That's a long answer to why they still do consultative evaluations when you clearly have, legitimate medical problems, specialists who see what's going on. It's just because of this residual distrust of the claimant's doctors. Okay. I think we answered this. I think you would just ask your lawyer to, download the ERE file, Electronic Record Express file, or go to Assure or Chronicle, one of these services, and get you a PDF. It's usually, it can be 1,500 pages. It can be 2,000 pages, but you can search it, and it's really. I will tell you, years ago, when I would handle a case, and I've done this for 30 years, so I'm talking about in the 90s. I have to go in, and I would have to make an appointment at the hearing office, go down to the hearing office, drive down there. I would have to check out files. There were these big yellow folders, multi-part folders that, this thick, you can see this thick, and I would have to check it out. I'd have to sit there in the waiting room with my little laptop, and I'd have to go and take my notes. Couldn't check it out, couldn't take it home. just had to sit there. And I could go through 2 or 3 a day, and if I was lucky, there was a room I could go to. Otherwise, I'm sitting with it balanced on my lap. Well, Social Security Insurance Credit a number of years ago went paperless. And so now we can log in to your electronic records express file, your Social Security folder, and we can download all the exhibits. And then to take it a step further, these services like Assure or Chronicle allow us to not only download it, but to pay $5 or $6 per case for a service to go in using our login to download it, put it together in a searchable file. And so we can much more easily review your file. I can do a search, like I'm doing a hearing prep, or I'm in a hearing. The judge says, do you have an MRI? I can type in MRI in the search bar. I can find it. Exhibit 17F, page 3 in real time. So it's gotten a lot better for lawyers because we have this access. So that, I would tell you, if you've got a lawyer, you can ask the lawyer to download your exhibit file and send it to you. If you don't, many times the hearing office, not before them, but at the hearing office, they will send you a CD-ROM, the CD with all your files on it. It's password protected. There's a code that they'll give you to do it, but it's password protected, and you can look at your record that way. If you are not at the hearing level, I think you can make an appointment to go into the Social Security office and physically look at your file there. I've never done that, but I think that there's a way to do it. But early on, I can get, once I get electronic access and I get it at initial or recon, I can look at the file from really very, very early stages to see what they've got. And many times I'll do that, contact my client and say, here's what they got, what do we need? Who decides if your skills are transferable? A vocational expert would do that. There is something out there called the Dictionary of Occupational Titles, or the DOT. You can go to occupationalinfo.org. I'll put this in the comments. The DOT at occupational, so I spell that right, occupationalinfo.org. Okay, and that is the DOT. It is outdated, last updated 35, 40 years ago. They still use it along with other things. And the DOT, you look up your job, there'll be a DOT code, 167.351-040. This is a sedentary, semi-skilled job. And if you look at the DOT, it will tell you the skills that somebody needs, and it'll give you an idea of what they are. But ultimately, the vocational witness decides if they are transferable outside of your industry. So if you have specialized skills in a particular industry, you're in the concrete industry, you're in the, battery industry, let's say, you may have skills, but they may be unique to that industry. Other skills, leadership, management, personnel, they may be transferable across industries. So it depends on what skills you've picked up and what you did. That's why you need to really think about describing your past work in a very accurate way. You may be have the title of manager or director or crew leader, but you may be a working crew leader that really had no authority other than just you're the lead worker, but you're the same as everybody else, and you don't really have any skills. You don't have hiring and firing. You don't make decisions about discipline. You don't set schedules. So it really depends on, that's something that your attorney can go over with you. But at the hearing, the vocational witness would decide if you have transferable skills. What do you think of these new rules from SSA? I think they're helping people. The new rules, if you're talking, Petra, about the look back, which is now they're looking back 5 years instead of 15 years, that definitely helps, because a job you did 15 years ago, is it really fair to assume that you still have those skills now, that you could go back to that job? 15 years ago, I suspect it was done a lot differently than it is now. So I think that look back rule is a real, it's appropriate, it's fair, because again, you're not going to know what you did 15 years ago, and more likely the job has changed dramatically in the last 15 years. That helps claimants. That's a good thing. I think that I know that they're postponing the CDRs, the continuing reviews for this fiscal year. Pardon me. That's a good thing. So, we have a commissioner now, Commissioner O'Malley, who is um, very much sympathetic to the plight of claimants. His focus is to try to deal with the backlog. Those are good things. What happens after the election? Who knows? If Mr. Trump wins, Commissioner O'Malley's gone. If Ms. Harris wins, then O'Malley may be, pegged for a higher office. He's done a good job, and they may move him to something more, more juicy. I know he was a presidential candidate a number of years ago. I suspect that he'll try to be a presidential candidate again. So, ideally, if he stayed in this position for another year or two, we may see some real positive changes. But, with politics, you just never know what's going to happen. Blue line, abolitionist. Okay, my benefit's $1,800 a month. Can they be garnished for student loan debt? I think for SSDI, they might be. I don't know. I know SSI cannot. I want to say SSDI maybe, but I just don't know. You're going to have to look that up. I used to know that because I used to do bankruptcy and student loan work. I just don't do it anymore. And I haven't kept up with it, so I don't want to guess. I don't know. Sorry, I don't know. But, that's something you can probably look up online. Or else call a bankruptcy or a student loan lawyer. There are lawyers out there that do student loan discharge work. And if you look up, student loan lawyer, you'll find people that do that, and they could probably answer that for you. Dog mom. I'm a dog dad. I think I had Sadie here last week, but she's not here today. She's upstairs. How can I prove I meet a listing if my case has already been filed? Well, meeting a listing is, proving that your medical condition is so serious that their functional limitations would be assumed. What you can do is, if you think you meet a listing, you can write a letter and file it to the adjudicator saying, please evaluate my case under listing, 5.04 or 14.02 or 1.13, whatever the listing may be. Here's why I think I meet the listing. Here's a medical source statement from my doctor saying I meet the listing. So when I'm doing an application, if I think somebody meets a listing, I'll put the listing in there. Please evaluate under this. And if I think I've got a listing level case, and most realize, usually if people meet a listing, I'll tell them, just go ahead and apply. You don't need a lawyer. Go ahead and apply. Tell them why you meet the listing, and the medical record will speak for itself. You don't need to pay a lawyer for it. But if I do have a case that meets a listing, I will identify that listing when I do the application, or I'll write a letter to the adjudicator. I've mentioned this before. I had a case several years ago, a fellow that I grew up with, my age. Unfortunately, he developed terminal lung cancer, stage 4, fought it for a while. And then finally, after really, he kept working. And then finally it got to a point he couldn't work anymore. He was just too sick. And he calls me up and he's like, can we file? I'm like, yeah, let's get this thing filed, so you can get, at least some money for your wife and because you deserve it. Quite frankly, you've paid into the system. So we filed it. What I did was I listing level case. And so what I did was I took the listing and I made a checklist form out of it. I sent it to his doctor. I gave it to him. I said, take this to your doctor, oncologist. She filled it out. I had, the statement that tracked the letters of the listing. I talked about, is this going to last 12 consecutive months? A few more questions. Do you think your patient can do X, Y, and Z? No, blah, blah, blah. Got that back, sent that to the adjudicator with a letter saying, dear adjudicator, Mr. So-and-so clearly meets this listing, this cancer listing. Here's what the doctor has said. Get his medical records. Please expedite approval. He's terminal. And I also pointed out it was a compassionate allowance case of stage 4 lung cancer. Referenced that too. And it still took 6 or 7 months, but finally, after 6 or 7 months, they went ahead and paid it. And he was alive to get it, and he died, I think, 3 or 4 months after that. But at least, he got, some money out of it. His wife got some money, and some of the bills were covered by Medicare. And I think it just, validated in his mind what he'd been going through. And I think, like I said, he was happy to have some money to leave to his wife. So, but that's how you do it. So you can, doesn't matter if you filed, if you think you made a listing, get the information to the adjudicator. Dear Mr. Best Lawyer, that's very nice. I don't know if I'd say the best. That's a pretty extreme adjective, but okay. I have a question. If SSDI benefits can turn into retirement, the same with, let me know. Okay. So SSDI, when you hit full retirement age, 65 or 66, they automatically make it retirement Social Security. The dollar figure is going to stay the same. SSDI and full retirement are usually pretty much identical, maybe a few dollars difference, but pretty much identical. But they automatically move it over when you are full retirement age. You don't have to do anything with it. But I would stay on Social Security disability as long as you can, because, again, you want to max out that retirement. There's no reason to take early retirement at 62. Dario Puig, I got turned down for depression, not worth it, $800 a month, easier to get a job. Well, Dario, I would say this. Social Security's position is if you can work, you should work. And I will tell you, honestly, working is a good thing in that you're socialized, you're out there interacting with other people, you feel better about yourself. So if you can work, you should. I don't think there's anything wrong with that. I think that's, kind of why they make it so difficult. They want people to feel like it's not worth it for $800 a month. And yeah, I hear that. $800 a month is not a whole lot. So, but I think if you can work, certainly try to do so. And if you can't do it, that's evidence as to why you'd be disabled. Cancer-free. I haven't talked to her from the ex-husband. I've not got any paperwork from find out if I'm married or not. He left me or abandoned me back in the 16, no calls or text. All right, now we're getting into domestic relations. There are, and again, depends on the state you're in, and I don't do divorce work. Did a few years ago, never again, not my thing. But it's pretty unusual that somebody would file for divorce and you would know about it. You've got to be served. It's a lawsuit. So you would have to be served with papers to show that litigation is commenced for a divorce. If he's not done that, pretty unlikely that you were divorced. Now, you could go onto the county record in the county where you live, or if you're in Louisiana, the parish where you live, to see is anything showing up under his name or your name to show that, there was a divorce. Is it unheard of that somebody forges names? No, it's not unheard of. So stuff like that can happen. But I think, that's something you can certainly try. If that doesn't work, if there's nothing there, if you're not divorced, then there are, and again, now we're getting into the far corners of my knowledge about this stuff, but there is a way most of the time when somebody wants to get divorced and the ex-spouse has disappeared to file using publication, where you can give him notice by publishing a notice in the legal newspaper of the county where you are filing for 4 weeks or however many weeks that your state provides for. So you're giving him notice you are being sued for divorce. And, if he doesn't respond to that, then, you can get a divorce. Now, whether you can get money at that, that's a whole different story. The other thing, of course, is, there's not a lot of privacy out there now. You might be able to hire a detective or somebody just to do some searching. Look on Facebook, look on, LinkedIn or whatever, and you can maybe be able to find him. And if you can find him, and if he's, let's say, in a different state, you can use what they call long arm. There's a lot of ways to get somebody served. I will just tell you, big picture is, if you can find the ex-spouse and get him served, that's the best way to go. If you can't, you have to do it by publication. That's less desirable, but you would need to speak with a divorce attorney about that. That is way beyond what I do. But I would say this, if he's been separated from you and abandoned you, I don't think his income would count against you, because you could certainly, make the case that you have no access to his earnings or income. Although I would say if he left you with their kids, or if you're entitled to alimony, maybe you could go after some of that stuff. Again, talk to a divorce lawyer, I think. Rashun Wheeler. Do doctors know if you filed a claim for SSD or no treatment differently to find out if a case open? No, there's nothing that no notice that goes to them, but Social Security will send them a letter saying, we need your records. So-and-so, Mr. Wheeler has filed for disability. We need your records. So that's how they know. But there's no notice that goes out to doctors or to anybody when somebody files for disability. It's just the letter that they send requesting records. That's how. Jay. How did I get a copy of my hearing? I heard they're allowed to get audio. Yes. When you go to your hearing, that literally a few minutes after the hearing, there will be an audio uploaded to your exhibit file. your lawyer can go in and download it. And it's a strange file, but most audio players can play it. And it's a zip file, and then within the zip file, there's I forget the extension on it. It's not like MP3 or something. It's different, something different, but most players can play it. Like I use, one of these just players that plays anything. It'll play it, and you can listen to it. And, a lot of times they tell you at the beginning of the hearing, you're not allowed to make your own recording of this. You can't live stream it. I couldn't live stream a hearing if my client said I could. But you can get the audio from it really immediately after the hearing. And, it's interesting when you listen to it. And I do this a lot, just to see how I did. And if I missed something, or if there was something that my client said, that I think needs to be clarified. But it's really interesting to listen to it, and you hear it from a very different perspective. Because when you're in the middle of it, you're just focused on what you're focused on, answering the questions. But when you hear kind of a big picture, you sort of see just the kind of the flow of it. So I think it's worthwhile to do. John says, regarding trial work period, our retired 223 regular SSA retirement, I'm thinking. Onset date for SSDI 3 of 23, return to work part-time, under SGA for 8 months, over SGA for 9 months, onset date. Okay, I'm a little confused about this, but bottom line is your onset date is the date when you did not have the capacity to perform SGA. So, if you were working at SGA level for 8 months, I don't think you could argue that you were not at SGA. If you were working at trial work period level as of the original onset date, yeah, you could make an argument that I was disabled, I couldn't work at SGA because I'm not at SGA level, but those earnings should count as trial work period earnings and not hurt me. So you could do that. But I think if you're working for 8 months at SGA level, then I think your onset needs to be after that. That's my take. Okay, so here is a free case evaluation. Garrett is putting that in there. I think I got this down here as well. But yeah, if you'd like a case evaluation, it'll take you to my website. If you use this link, it will tell me, I'll know that's where you came from. We can track, because we like to track to see how effective these live streams are, as well as my videos. So that's why I use that particular one. This link here, the Contact Jonathan 3 link. Zippy, I've not worked since being an SSD, then you should have anything to worry about as far as a CDR. Okay. Garrett is my practice management consultant. So he comes to most of these live streams, and a nice guy. And he lives in deep, dark Michigan someplace. We've actually met in person once or twice, I think, at least. But nowadays everybody does stuff over online, but we have met in person. But we talk almost usually once a week, if not more than that. And good man. Okay. Deb Lindley, Blue Line. If you have federal student loans that are default, they can garnish. Okay. So I'll take what Deb says at face value. I do not know, but I thought that you could. Not SSI, but SSD, I think you can. Bullfrog and Crew. Good evening. I have a hearing at the end of November. I'll be 49 years, 10 months. Do most judges take that into account as magic 50 black and white? That's a great question. I will tell you, that is a very good question. The answer is that some judges will use what they call the grid framework. So if you're 49 and 10 months, they can apply the grid. Now, realize at November, you're going to be 49 and 10 months. Your onset date might have been at 48 or 47. So the danger to using the grid rules at 49 and 10 months is you may get approved, but no past due benefits because, and there's a 5-month waiting period after that. So yes, you may get approved and that may be what you want. But my point is that the grid framework can be applied here, but maybe as far as getting past due benefits, you want to argue that your functional capacity as of your original onset date was so eroded by your medical problems that you were not able to function. But yes, a judge could use the grid framework. Okay. Let's see. If I filled an application online, they won't need more. Again, sometimes they want no information about your earnings, your income, your household situation. They may need to know about your medications. When you filed your application, there may be the stuff that was left out, and so they don't want to fill it in. And I will tell you, I'm doing a lot of applications, and I do them, I file a lot of applications for people, a lot of recon appeals, hearing requests, and, they ask a lot of questions. That's kind of why people sometimes have me do it. They ask a ton of questions, and it's a pain, and sometimes it's easy just to skip it, but then Social Security wants it, so they'll call you or they'll call me and say, can we call your client about finding out when he graduated high school? Like, that makes a difference. But they want that information, so they'll ask for it. My sister is blind, the left eye, the right side is legal blindness when she started applying. There are special rules for blindness. And if you look at the listing, let me tell you which listing it is. The listings for visual is going to be listing 2. It's going to be 2.02, 03, 04. And if you look at the listings, go to meetalisting.com, and I'll put that in the comments here. You can access the listings, meetalisting.com. That's where you can find the listings. That's the website where I talk about how the listings work, but I also have links there. If she meets a listing for visual, and generally speaking, one of these is they're looking at 2200 or worse in the better eye, or significant loss of visual acuity. The amount that she would get is actually higher than the amount that you get for other types of impairments. So that could be certainly a positive thing. But I think my experience has been, generally you need to be listing level to meet a blindness, to win for blindness. I have had a couple of cases where somebody just, that's very nice. Somebody just did a $10, paid or gave me a $10 donation, which I really appreciate. I'll see what that is in a second. But I really appreciate that. But yeah, Joel, look at the listing. Look at the listing 2, and if the doctor says she meets a listing, then you would then apply. Otherwise, you can argue functional capacity based on blindness, and I've done that. That's usually of people that are older, over 55, and they've got something else, maybe severe depression, maybe some knee problems, other things. So blindness not at listing level plus something else can usually work, but blindness alone, you're going to need to meet a listing, and listing 2 would be where you want to go. Let's just see. I just want to see. Lulu's After Party. Thank you very much, Lulu's After Party. And that was very, very nice of you. I really appreciate that. Okay, for a super sticker. I'm not sure what a super sticker is, but I'm sure I'll find out soon enough. Terry Jones. I received a letter saying I need to pay taxes. Went to file. They said I didn't. The filing process, but I owed nothing. Why would they send a letter? I don't know. Who sent? I'm not sure who's. I mean, generally speaking, if you type into Google, do I have to pay taxes on SSDI? There's several really good articles. I think one's from NOLO. There's a couple ones out there, maybe one from H&R Block. It depends on household income. And most of the time, people on SSDI do not have to pay taxes. You may have to file a return, but you don't have to pay taxes. But that is not all. So I think I would look that up or talk to maybe a H&R Block person or an enrolled agent, which is like a person who's able to practice for the IRS, or an accountant. They can tell you. They can tell you about that. But look it up and you'll see very clearly. There's some rules about it as far as the amounts when you might have to do it. But generally, if all you're getting is SSDI, you probably won't. All right, Daryl has a lot of bad things, and an RFC that will miss 4 days of work. Yeah, I think if the judge accepts the psychiatrist functional capacity form that says you're going to miss 4 days of work, you've got all these things going on, you've got some significant abdominal issues, that would be a winning case. Now, I will tell you that, you need to have medical records in addition to what the doctors are saying in their forms. So there's got to be treatment records. But if in fact there are treatment records describing what you have on here and support from your doctor, that is a very, very strong argument for your case. Greg, how are you doing, Greg? I'm glad you came by to say hello, and I hope that you find this useful. I know we emailed during the course of the week, and I'm good to see you here. Is there any benefit to SSDI if I move my onset 1 year before my alleged onset? Okay, your onset date, alleged onset is the same thing. So if you're asking, does it make sense to move your onset date? Judges want to make your judge's life as easy as possible. I don't like when people have an onset date 10 years ago, and then they've worked after that, because it doesn't make any sense. If you're disabled and you worked at SGA level, you're not disabled. So your onset needs to be realistic. It needs to really reflect when you lost the capacity for work. So you want the earliest possible onset date you can have. But there are situations where, let's say that you stopped working in February of 2022, but you did not go to the doctor until February of 23. Well, at that point, you might want to change the onset date to when you start going to the doctor, as opposed to this date when there's no medical support there. That's a judgment call. That's a strategy call. That's something that your lawyer can help you come up with. But when I'm going to a hearing, there are times when I'll tell my client, we need to change the onset date because we have a good chance at winning, but there's no medical evidence going back 4 years, but there is medical evidence going back 2 years, and we can make that work. Again, my hearing today, the one that I won on the record, I had to change the onset date. The client had put an onset date prior to the, basically a year before prior unfavorable hearing decision. Well, the hearing decision is what they call res judicata. It is a thing decided. They're not going to relitigate that. So we changed the onset date to the day after the unfavorable decision. Judge went with it. So sometimes you have to change it, but that is a strategy decision that you and your lawyer would need to talk about. Theodore Matushia. I hope I pronounced that right. Theodore. Hello, sir. Hello back. A question. I was denied from my hearing my case at federal court. My lawyer told me the hearing judge has changed her mind. I'm not sure what you mean, but if you go to the federal court and it's remanded back, you want the judge at the hearing to change his or her mind. And, crazily enough, it usually goes back to the same judge. Some judges are sort of intimidated by getting a federal court remand. Others could care less. Now, there could be some things that have changed. Again, the big one is the look back. So if you were denied at step 4, meaning that you could return to past relevant work, and the judge used past relevant work that was done more than 5 years ago, you go back for a remand hearing, the judge is going to have to give you a different decision. So it's just going to depend. But I'm not sure, when the hearing judge has changed her mind, I don't know what that means, but if the case is still at federal court. I don't know that the judge can redo the decision if the case is at federal court, but when it's going back to the judge, you want them to change their mind. Okay. So your ex-husband's in Thailand. So again, and I will tell you that this is the person who might want to file for SSI, income-based or income and resource-based, but the husband has disappeared, maybe in Thailand. You need to speak to a divorce lawyer about doing either a long arm jurisdiction service on your ex-husband or do it by publication. And depending on where you live, there are ways to deal with people who have flown the coop, in Thailand or any place else. But that's not something that I don't know much about, but I think that I would definitely say you should talk to a divorce lawyer about it. Kimmy, very nice. Thank you very much. I really appreciate that. Suki, my pleasure. I don't know if I gave you the answer, but I'm trying. I hope you get some benefit out of this. Okay, yeah. I think this is something Garrett put up here, and what we're getting. I think this is somebody asked about the changes, and so one of the things they did was they changed how they look at repayment rates. Used to be they were really hard line about when you had to repay an overpayment. Now they've reduced the amount that they will ask you to give back. So that is definitely a helpful type of thing. Okay. Let's see here. And I must have put this on a blog post. Okay, or the SSA's blog. That's what it's there. So there's some talk about that there, about reducing the overpayment burden. That's another thing that the commissioner has done, which I think a lot of people were very angry with Social Security, that they were going after people who have very little and they're demanding these huge repayment burdens when they got nothing anyway. And half the time they're overpaid because Social Security can't get notice to them fast enough. So that was something that O'Malley did, which was appreciated. Well, applying for a passport effect, no, has no effect on it whatsoever. Where do I go online to see your progress? You can set up your My Social Security account. Again, go to ssa.gov/my account. You will see there, pardon me. You will see there a statement showing the progress of your case. Unfortunately, I don't think it means a whole heck of a lot. It's just a number, a percentage, but it doesn't really mean very much. So I think it's kind of a waste of time. But you can see that it's being processed at least there. And honestly, when I log into somebody's account, I can't see the percentage where it's at either. I just know that it's being worked on. I'll look to see, has there been anything recent going on? If I haven't seen anything since February of 24, I get on the phone. Why is nothing happening? Or I write a letter. So that's how you kind of know. Connor's Canine Cookies has been here before. And Sadie asked me to mention that she likes Canine Cookies. Just throwing that out there. And my address is on my website, by the way. If a decision is made but is being processed, you call the local OH office. Will tell you the decision. They will not tell you. They will not tell you. You have to wait for it in the mail. Again, I get it early because I have the service that does it, but you call them up, they won't tell you. It'll be mailed out to you. Sam the Man, I'm 60 on long-term for a year. Sorry, I do back injury. Recently applied for recon. Is it true that I should not bother reporting past medical injuries prior to 6 months? No, I think that I think those things have historical value. Again, it's not going to be determinative, but I think that I would definitely it's part of the picture. Remember, in a disability case, you're painting a picture. You're creating a narrative of your life. And so, there's a theory out there or a term out there called worn out worker. I use this a lot in my hearings. Well, I'll say to the judge, look, my client's 60 years old, has had physical jobs, back, was in the military, jumped out of airplanes, worked for a concrete company, worked in a concrete floor warehouse, just worn out. And even though he was able to work through these things in his 30s and 40s, this is all part of the picture. So I think that's all very relevant, and even if it's not something that shows you're disabled now, it shows history of it. You're not coming out of the blue. You're not, just being created out of thin air. You are the sum total of your experiences and your injuries from the past. So if you've had prior stuff, that is part of it. I'm doing a brief. I'll talk about that. My client has a long work history, but also, has had previous back surgeries back, 20 years ago. Scar tissue is formed. My client had a very physical work history. My client played professional sports, played college football. I've had a few like that, and had a number of concussions. That's all very relevant. So I think I would definitely mention it, Sam. Okay. I sent you an email a few days ago, so I've been busy. I understand if you haven't seen it yet. Send it tomorrow. Okay. Please do. SSDanswers123@gmail. That's the best way to reach me. SSDanswers123@gmail, and I will make sure to look for it tomorrow. Mike Donahue, my birthday is November 5th. I turned 67, become full retirement. Disability become, yes. Yes, it will. It will. Theodore says hello to Garrett. When someone submits a claim to SSDI with a grid rule, GRID, not grind, it's grid. What step does they consider grid rule? Step 1, 2, 3, 4, 5. Okay, what he's talking about is the 5-step sequential evaluation process. And to go through this, step 1 is, are you working? Step 2 is, do you have a severe impairment? Step 3 is, do you meet a listing? Step 4 is, can you perform past work? Step 5 is, can you do any work? The grid rules are going to really come into play at step 5, because if you can do past work, then the grid rules are not going to apply. So it's a step 5 evaluation. They're going to look at the grid rules when they're at step 5. But you got to go through steps 1 through 4. But if you can return to past work, then they're not going to get to the grid rules, because that is, shows you have the capacity to work. Hell to the gnaw. Okay. Hemophiliac with ankle fusion pain. Doctors need another surgery. I would say this, hemophilia is obviously going to limit you in terms of dangerous moving machinery, unprotected heights where you could obviously cut yourself. But there are a lot of jobs that hemophiliacs can do that you're not going to be in that danger. Ankle fusion pain may limit you to sedentary work. So if you are over 55 or over 50 rather, that may make your case that much stronger. If you're under 50, theoretically, you could, unless you have severe pain, if you're 45 years old, you're a hemophiliac and you've got right ankle fusion pain, there may be sit-down jobs you could do. Therefore, you would not be disabled. So I think that that's really going to depend on your age and the severity of your condition. But the hemophilia is going to limit you from some jobs, but not everyone. Lulu says, I appreciate you, and she was nice enough to buy a super sticker for $5, which I appreciate that. And again, I've told you before, I don't drink coffee, just don't like it. Not that I have any reason not to drink it, I just don't like it. Do drink hot cocoa, but it's too hot. So the $5 would buy me a sandwich, which I appreciate. Love a good sandwich. Go to a good deli. There's an Italian deli near me that I go. In fact, I went there today. Got a really good mozzarella and tomato sandwich. Really, really good. So do that, or I'll go get an ice cream cone or something. So I really appreciate, the super stickers and other donations. That's very, 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 very much appreciated. Deb says, so Suki, I'm not sure if Deb, what her credentials are, but she would need to know Suki's state for SSI questions. Maybe it was Deb, are you the adjudicator? I think there was somebody who was on maybe a couple of weeks ago who is an adjudicator. Maybe that's Deb, I don't remember. Jenny Joe. Hello, Jenny Joe. The DDS said their doctor wants a consultative. I have a new MRI evidence. My doctor's saying I need a listing. Adjudicators that receive these may cancel the CE. Okay, well then you've got an adjudicator who has a clue. Where if you've got a MRI evidence of a listing level impairment, your doctor says you need a listing, the adjudicator is a person who's like, okay, we're not going to waste everybody's time with the CE. We're not going to waste the agency's money. This person meets a listing. Let's get her approved. That's a good thing. So you've got a smart adjudicator. Okay, held to the gnaw is the hemophiliac with ankle surgery, getting paid through Hartford, tried applying for SSI, getting income from the Hartford, married with one child. All right, if it's SSI only, then yes, your LTD would offset your SSI, because that is a resource that would be too much, and especially if your wife doesn't work, so that wouldn't be an issue. But the $1,500 would offset SSI, so that is not surprising because it's a means-tested program if it is SSI. Do I do SSI hearing appeals? Occasionally, most of my cases are SSDI. I'll take an SSI if I feel like there's not going to be a lot of offsets. The problem is, you don't always know. And I've done SSI hearings, I will tell you, where I win the case, and then it turns out I had one case, I got $64 for my fee. I can't stay in business with that. So obviously, I'm just reluctant to do them. So I'll do them selectively, but I'm real careful because there's just too many times when I've done SSI cases and not a dime comes in, and it's, okay. Sue, yes, you have your case, recon, have enough work credits, ensure can pay bills. Yeah, this is a problem. And Sue, you're not the only person, not my only client who's dealing with this. You have a case, a good case, and it's just taking forever. And, what we may want to do is contact your U.S. Senator, U.S. Representative, and see if we can ask for dire need, ask them to do a congressional inquiry to expedite that. I'll make a note of that, and we'll look into doing that, because I know, you got no money coming in, and, and again, you could do part-time work, but, you're limited to really, less than $1,500, not going to do much. And I'm not going to go into your case, whether you could do it or not, but yeah, this is a big, big problem when these cases can take 2 years. And I've had people go back to work because they have no choice. But we'll take a look at that. Jackie, husband stopped working as an order selector due to degenerative disc disease, stenosis, osteoarthritis, spondylolisthesis, has a Gulf War veteran, PTSD. How old is he? I mean, I think those are legitimate medical issues. I'm just going to write down Sue's information, so I don't forget that. Okay. Yeah, again, you don't win based on diagnosis. You win based on how these medical problems impact your husband in a work environment. So, and if he's over 55, the grid rules may likely, disable him. If over 50, they might disable him. If he's under 50, it's got to be pretty severe. Now, again, Gulf War PTSD, I see a lot of that. I will tell you, Social Security, even if he's 100% VA disabled, doesn't necessarily mean you're going to win. It's got to be how severe is it? What is the treatment saying? So again, all these symptoms could be disabling. It's just a matter of severity and how old he is, as I would tell you. Do the grid rules apply to this type of claim? They apply to the physical part of it, the degenerative disc disease, stenosis, osteoarthritis. They do not apply to PTSD. Grid rules do not apply to mental health cases. They do apply in the sense that the PTSD might eliminate transferable skills. But in order to find that he meets the grid rules, his functional capacity needs to be limited to light or sedentary, which is a physical limitation. So yes, the answer to that is yes. He's 56 years old. In that case, the grid rules at light would apply. The argument would be that he is limited to no more than light work or less. And even if he could do light work, these problems, if they're properly documented, would limit him to light work, and the PTSD would eliminate transferable skills. That is the argument I would use under the grid rules. In the alternative, I would argue that his functional capacity for work has been so reduced by the combined effect of all these things, medication side effects, that he would not be reliable. So you would argue both, but I think the grid rule 202.06 would likely apply here. Madeline from my office, how are you doing? Okay, this is where I put in DOT, okay. I'm 48 years old. Yeah, okay, 48 years old. You're one applying for SSI with hemophilia and a bad ankle. Yeah, it's going to be hard because I think that there are sit-down jobs that exist that you could theoretically do. And at 48, you're not going to meet the grids. And of course, you're getting LTD, long-term disability, so there's not going to be any SSI. It's offset. I'm thinking that, stick with the long-term disability as long as you possibly can, and then, hopefully you can go back to work, because I think that is going to be your best bet. Vincent, good night. I will look forward to talking to you. Rebecca with a K, can you appeal again after denial of the same appeal? If you went to the appeals council or district court and it was denied again, you can appeal it again. Yes, you can. You can appeal it again. Rock, moderate hearing loss with hearing aids. How much emphasis will be placed on hearing loss? That is probably not enough to win a case, because there are jobs you can do where there's very little interaction with anybody, coworkers, supervisors, and the public. So I think that moderate hearing loss is generally not going to be enough to win. I think if you're totally deaf, that may be a listing, but I think if you're moderate and you need hearing aids, no. Jen is my parent. So I've got Jen and Madeline on, both work with me, and good to see both of you there. The dude who's here every week, thank you. How do I figure the stress level of construction work with heavy sheet metal working HVAC? Well, if we go to occupationalinfo.org, let's do that right now. And let's see here, screen. So let's do that. And let's just look construction worker, sheet metal. Let's see what comes up. Oh, that's not it. That's a job. Okay, let's see. Construction. Let's just do construction worker. Okay, so here is there's different types of them. construction worker 1, construction worker 2. Let's see, this one looks more of a concrete, heavy sheet metal worker. All right, let's just use construction worker 1. Let's look at that. It is a heavy job, that sounds right, with an SVP of 4, which is semi-skilled. And it's really not a stress thing here going on. These terms here, reasoning of 3, mental, which would be like education level of 3. So I don't know that there's a lot of stress in this job. Now, some of these things I don't deal with very much, so I don't want to give you, I don't remember all what these things. I know that reasoning is 3, and I think M is 3, maybe mathematics is 3, language is L for 3. So I don't think there's any stress issue there. The question is, how would stress, and an SVP4 is a semi-skilled job. So I think that if you have severe PTSD, there's not going to be a lot of transferable skills from a heavy job to anything light or sedentary anyway. So I think that's going to eliminate that transferability of skill. But if there were transferability of skills and you have a high degree of stress that makes it hard to focus and concentrate, or you might be a danger to yourself or others, you could do that. But I think the better argument here is that a heavy job, by definition, is not going to have transferable skills. Oh, I don't think you're seeing the page I'm saying. Let me change that. Let's go back to a different page here, because I think with this one I've got to do a different page. Okay, so here's construction worker. Let's go through this analysis again. So here we have, let me make it a little bit bigger. Oops. Here we have the strength is heavy, okay. GED, this is reasoning of 3, which is pretty low. Math of 3, pretty low. Language of 3, pretty low. SVP of 4, that's semi-skilled. Not sure what DLU stands for. I don't know. I'll have to look that up. I should know. I don't know off the top of my head. But the bottom line is that this job being a heavy job, if you look at the grid rules, they talk about transferability of skills. It's got to be transferred to a lighter, or the same or lighter level, generally a lighter level. So a heavy job like construction, what skills that a construction worker has are going to be able to transfer to a light or sit-down job? None, especially if your skills are semi-skilled. So I don't think that's going to be an issue at all for you. I think that the transferability of skills is not going to be a problem. The grid rules were designed to help construction workers. So I think that would be where the grids would come into play. All right, so Garrett says hello. Garrett's found a new avatar there. Okay. Okay, with that income, I think Deb's talking about the gentleman who is getting $1,500 from long-term disability. Make a standalone bank account. I think what Neo Eclipse is saying is create a segregated bank account that is not commingled with other things. I still am not sure that that's protected. Student loans are protected from SSI, is going to be protected from student loan garnishment. I just don't know. Are medical imaging CDs valuable for my attorney to have, or is a doctor's report? Doctor's report. You don't want to, they're not going to look at imaging. They're not going to look at a CD with an image. And now I've seen situations where I send in a picture, like a picture of my client with a bad scar, a broken leg, or swelling. But but they're not going to look at an MRI. They're just not going to do that. But I think that the report is really what you want there. Okay, Garrett's saying hello to everybody here. Can you share the doctor checklist you sent from me listing expert? It depends on the listing. The one that I did for my friend was a lung cancer one. So every listing is going to have different checklists. And literally all I did was I went to the listing. I'll show you what I did here. Let me share that screen here. Lungs, okay. All right, so I will show you exactly what I did. So I went to this listing here, the lung cancer, okay. So I basically copied this onto a Word document here, and I just put little check boxes around A and B and C. And I sent it to the doctor. I said, check which one applies here. I think in his case, he had small cell carcinoma. Then I put additional questions, if I remember correctly. When did this first apply? Is this likely to last 12 consecutive months or more? Is there any effective treatment for it? That's it. And that's all I did. So that's basically how I did that. Okay. Donna's been here before. Still chiming in, no questions during. Enjoy my upcoming breaks. Thank you, Donna. I will hopefully do so. We are going to the Charleston, South Carolina area. So I'm hoping that will be a fun vacation. So we will see. We'll see. Dee says, thank you. Keep watching, helping get this process halfway crazy. Half crazy is better than being fully crazy. In the 7th month of waiting for initial decision, yeah, it's a long time. It's a really long time. Okay, I'm 43 and have been outside of work since April due to mental issues. Up to prescription, I knew one pill for medication. Okay, so you've got a mental health case, PTSD, depression, panic attacks. Again, those are very, very hard to win. They just are, because they're invisible. And so they're just hard to win. I wish I could tell you otherwise. So, and especially if all you have is VA records. So you're going to need to have document a severe level of impairment. And that's just the reality. Excuse me. I apologize. I played tennis today for 2 hours. So I'm a little tired. And I'm old. That's part of it too. But yeah, those are just hard cases. And I wish, you may have better luck at the VA. But those are just very, very hard. Enjoy my vacation. Thank you. I'm going to what they call Isle of Palms, which is right near Charleston, and going with my family and my 1-year-old granddaughter, which is going to be a lot of fun. She'll probably try to eat the sand, but she'll be able to see it in the ocean for the first time. So it's going to be hopefully a nice time. We're looking forward to going. If anybody's in Charleston, knows some places to eat, let me know. Appreciate that. Okay, so I know Garrett's going to get on me for not putting this out there. Free case evaluation. Okay, there we go. Comments again. Okay, let's see here. I missed a couple up here. 51 male with x-rays, MRI evidence, spine issues, double scoliosis, x-ray, 100% VA disability, hearing x-ray with LJ, medical x-rays. I think MRIs are more powerful than x-rays. X-rays only show bones. MRIs show soft tissue. So I would tell you that MRI evidence is a lot stronger. If you have, a medical source statement from an orthopedist, that would be helpful as opposed to a family doctor. And, I think the objective evidence is really the big thing here. But I think MRI evidence is more powerful than the X-ray would be. SS applications approved, payments received, but accumulated savings to the. That's why the answer is possibly if your SSI lump sum comes in. That's where they pay it in 3 installments, by the way, so that they theoretically you're going to use it up between installments. So if you get, let's say, $10,000, they're not going to give you $10,000. They're going to give you like $3,300, and then 7 months later another $3,300. So the money from SSI won't disqualify you unless you don't use it up. That's the best way to answer that. SSDI is not an issue, but SSI is an issue. Does having an addiction on methadone make it count as a disability? On methadone through state and have a lower neck and back and super medicine I take. Methadone is a prescription medication. It is a substance. The question is, the question they're going to ask is, being on methadone, if you are not on methadone, would you be able to function and work? There's a reason you're on methadone. Is it because you were a heroin addict and they use that to keep you off of that? Is it a pain? Methadone is used as a pain medication. It just kind of depends. I mean, it's never good to use the word addiction in a Social Security case. You're in a maintenance program. And if you're saying I'm on a maintenance program and that maintenance program is making me disabled, that could be a hard argument to make if the reason you're on a maintenance is for substance abuse. If you're on methadone for neck and back and so forth, that is more legitimate. That is more of a pain management kind of thing. I think that would be less of a problem. So it says here that you're on methadone. Maybe you got off prescription meds, Percocet and oxycodone and all that stuff, and you're on methadone for pain management. I don't think that's as much of a problem. Okay, that's my opinion. But it's something you're going to have to deal with, and your attorney will have to deal with that. Kevin says, 8 years of medical evidence to the VA to main listing on grid rules, last 12 years housing office. Kevin, it's you're 51, so you can certainly look at the grid. I don't think you're going to meet the listing. My experience has been that the listings are really hard to meet for musculoskeletal. They make them really hard. I would look at the grids, at the sedentary grids, and see if one of those applies. That may apply. That may be, you've got a long work history. I think the listing's unlikely, but possibly one of the grid rules that's sedentary. Maybe take a look at grid rule, and you're 51, so maybe take a look at grid rule 201.14. 201.14, see if that one might apply. That would be what I would probably argue. Okay. St. Louis, I'm highly skilled. Well, you know what? I've been doing it for a long time, and I think I know what I'm doing. So again, I'm hoping that I'm giving you good information. I think it is, but I do feel I'm pretty knowledgeable in this. Just you do enough hearings, and you do enough cases, you kind of get a good feel for it. Now, I've got a good staff that really helps, and look, this is a nice community of lawyers that do this. There's a number of lawyers I communicate, like my friend Stephanie, who you all have met before, my friend Greg, who is a former Social Security employee. There are Greg Brinkley. There are some good people that I know. There's other lawyers that I interact with, Carl Osterhout, Lindsay Osterhout, very, very nice people. There's other people I've met at conventions. So it's a nice group of people that if I don't have an answer to something, I can call somebody and say, what do you think? There's a listserv through NOSCAR, the national organization, and I ask questions on that. I give answers on that. So so I think it's a community effort. I think that most of the people in this area really want to help people who are in need of it. Marcia is denied SSDI, disability retired first, but the AJHR says I can do my last job. Herniated disc. I'm not sure if you meant you went to a hearing. You said that did the ALJ hearing. I don't know, where you are in your case. If it's an initial or recon, you can appeal it. But if you went to a hearing, you have to go to the appeals council. And if you were denied at step 4, you could do your past job, then you're going to have evidence to show that you could not. And I think you appeal it, and the evidence may be enough to support an appeal. But the appeal, they're going to look at how the judge analyzed the evidence. Did they make a mistake in analyzing the evidence? No. Okay. Do I imply I don't do cases at AC, but I don't want to upset the LJs? Absolutely not. I don't. Believe me. I mean, as an attorney, I'm doing what I got to do for my clients. I am not concerned about an ALJ who's going to get offended because I appealed them. There's a couple of ALJs I appeal all the time. I mean, there's one guy in Atlanta who denies cases you shouldn't deny, and he's sloppy. I appeal him all the time. Don't always win, but we appeal him all the time. So I will appeal and a judge, and most judges, it's business. They don't understand you're doing your best. Look, we have an obligation to be a zealous advocate for our clients. So I am not going to refuse to do an appeal because I'm concerned the judge is going to be pissed off at me. I mean, too bad. Now what I do with appeals is I usually will bring in somebody else like Osterhout, like Brian Konoski, that do nothing but a federal court work or appeals counsel work, and so I'll co-counsel with them. They'll draft up an appeal, I'll modify it, I'll file it. So I usually get help with it because it's just a different area of law. And I'm so busy with hearings that to keep up with all the case law is difficult to do, but I'm involved in it every step of the way. But if you got that understanding or impression that I don't do cases at federal court or district or appeals counsel because I'm concerned that the judge is going to be upset with me, no way. I'm not concerned about that at all. I mean, judges, even judges I've appealed, and they know I'm just doing it because I got to do what's right for my client. They don't take it personally either. Okay. Pedro, I was approved for SSDI in June with an onset date of October 21. When should I expect a review? 51 years old. Well, there's no reviews in this year. So I think that, it depends, actually, Pedro, there is a code that they assign to your case. And if you get a continuing disability review statement, that code will be on there and there's a way to interpret it. I don't have one in front of me, but you can tell how they evaluate you. Are you a person who's got likely to have medical improvement or not? If you don't have likely medical improvement, you may never get reviewed, or it may be a review in 5 or 6 years. I would tell you, if you got approved at an onset of 21, we're now in 24, assume they're going to review you in 24, 25. If they do, and you're still going to the doctor and you're 51 now, I think it's unlikely they would terminate your benefits. I think that, if you're still going to the doctor and things have not gotten better, now the grid rules apply. It's just, I don't see a lot of reviews and terminations after 51 or after 50. I would say that one of the questions here would be, have you gone back to work at all? Is there any work history? No work history, no medical improvement, you're going to the doctor, you should be just fine, I think. Cass Richards, thank you for buying the super sticker. I appreciate it. And the next sandwich I get, I will raise a sandwich or a potato chip in your honor. I really appreciate that, both you and the person who did before, which I really appreciate. Jay Tatum, I'm a self-employed attorney who found your videos about a week ago of constant spasticity, pain, pervasive, I think is what you mean, pain all day. I've overprepared on 115 ABCD with unemployability, but thank you for your video. Okay. If you got a listing at 115, great. And obviously as an attorney, you are familiar with how to present a case. Not obviously, but obviously you were. And if you got on because you meet a listing, that's ideal. Look, I've said this many times. People that meet a listing, I will usually tell them, apply on your own. And here's the list. I'll sometimes send them the listing to use, to reference. Get on your own. Do it on your own. Don't pay an attorney. But if meeting a listing is hard. It's really, really hard, especially in listing 1, the musculoskeletal. It is really hard to meet that listing. So, kudos to you, because that's hard to do. And you did it. Cass from Coffee and Donuts. Okay, I don't drink coffee, and I don't need to be eating donuts either, but maybe a sandwich. But, you're okay. Hayden had his hearing yesterday. Okay, good. That's awesome. Good for you. Let's see what else you said here. I was still working a lot in 22. Okay. And again, remember, you've got the trial work period. You've got the SGA issue. So, you may be able to do some work as an attorney and not take yourself out of disability. Joel, thank you for answering your sister. Well, to you and your sister, Maya, you're very, very welcome. Are bank bonuses considered earned income? Bank bonuses, if you work for a bank, yeah. But if you just simply got if you open an account, and they pay you $300 because you opened an account and kept it for a year, that's not going to be considered income. But if you work for the bank, you got a bonus. Yes, that would be considered income. Can you explain trial work period? It's a little complicated because it's It's sort of bizarre the way they do it. Again, I'm going to have an article about this coming out on my website next week. I was trying to get finished today. I couldn't quite get to it. But basically what it says is that after onset, for any 9-month period of time in a rolling 5-year period of time, so every month that goes by, it's that 5-year period of time keeps moving down the line. But let's say in any one 5-year period of time, you could have 9 months of earning up to the trial work period amount, which in 2014 is $1,110. So if you earn $1,109, you don't trigger a trial work period month. If you earn $1,111, or let's say $1,200, you use up one of your 9 trial work period months. You have 9 of those to use up. So you could earn $1 million a month for 8 months and still not affect your disability at all because it's trial work period. But once you use them up, okay, now they're going to look to see, are your earnings over SGA, substantial gainful activity, which in 24 is $1,550. If you go over SGA, you're in overpay status. So trial work period is just basically a way for you to test the waters and earn over $1,110. Not that that's all that much money, but at least it gives you some idea whether you can do it. And that's what it is. And so you got to be careful because you may use them up. Realize 5 years, let's say you use up 2 this year, 3 next year, 4 the following year. You may use up your 9 months and not even realize it. There's no way to know. So that's why it's when does the 5-year, the ones from 2024 roll off in 29? You're not going to remember what you did, unless you keep track of it. That's the problem. That's the problem. So, but look for my article. It'll be on forsocialsecurity.disability.com under the FAQ section, forsocialsecurity.disability.com under the FAQ section, where I've got a little bit there about the confusing numbers, but there'll be something specifically about trial work periods, I believe next week. Once recon is assigned, how long will it take? It could take 6 to 12 months. It just depends on how busy the adjudicators are. Is SSAA of any money? I believe they are. I believe that they offset it, if I'm not mistaken. I don't deal with California cases a lot because it's all virtual. I can do cases all over the country, but I think that the year you get from EDD would offset your Social Security. I'm pretty sure of that. But you can check the EDD website. Got approved on the 23rd. Good. Congratulations. Been watching your channel for 3 years. Very helpful and informative. Thank you. Well, thank you very much. I appreciate that. If you would not mind, leave me a review. You can go here to do it. So if you got value out of my videos and you got value out of the live streams, then please leave me a review. Our attorney friend, Mr. Tayden, spinal cord compression injury, 53 years old. Yeah, I can see why you need a listing. Still hard to do. Still really hard to do, but congratulations to you for doing it. Okay. 60-year-old tennis ball side colon cancer removed, right kidney removed, very aggressive cancer, medical review since 5. You should win. You should win. I'm sorry you've gone through that, but you should win. I think that, not only, now realize you had cancer removed in 2018, so I'm assuming the cancer is gone, not creating issues. The kidney removed may create some issues as far as excessive urination. Again, aggressive cancer, but, potential problems down the road don't mean you're disabled. The question is, what are the specific activity limitations, Tracy, that now affect you? Having, 2 aggressive cancers don't make you disabled. The side effects of medication, the effect of the cancer, if you have an active cancer might, but having had them in the past, and hopefully they're in the past, won't recur, that does not make you disabled unless you're on medications for maintenance that cause a lot of side effects. So that's really the question, is why would these things prevent you from working? It could be fatigue. It could be any number of things. But, simply having a past history of cancer, and again, let's hope it stays in the past, does not disable you unless you've got something that's preventing you from working now. Now, if your argument you were disabled, 4 months ago, yeah, I think that if you're still recovering from that surgery, that could be an argument too. But at some point, unless you've got ongoing things, at some point the treatment comes to an end, and at that point, you may have to prove that something else is keeping you disabled. But while you're undergoing treatment, or while the symptoms were very severe, then you could certainly argue for disability. James, you've been here before too. Had my hearing on August 2nd. After the judge finished her questions, VE said there are no jobs. If that's what the VE said, yes. And I will tell you, to be fair, I had a gentleman who reached out to me last week, real nice guy. He said, I went to a hearing and the VE said no jobs. Okay, send me the file. So I listened to the hearing, listened to the whole hearing. And the judge asked the VE questions. The VE says he could do past work. So again, he heard it. That's what he remembered. I'm not disputing that's the way he remembered it, but that was what happened. So that's why I would tell you, James, get a copy of the audio and listen to it, because things happen real fast and maybe the judge didn't say that. But if in fact the judge said, or the VE said there's no jobs, no question asked, said that there were jobs, then you probably won. As someone who's been through this process and we're going to federal court, me to say, okay, thank you. Yeah, I think you don't want to go to federal court on your own. So again, I look at cases. I have people sometimes that reach out to me who have lost at the hearing level and they want me to look at it for appeals counsel. I had this one gentleman who lost at the appeals counsel, asked me to look at it for federal court work, and I will do that. I will look at it. I always get a second person to look at it too, because sometimes, two brains are better than one. So yeah, I'll make sure that myself and somebody else look at it, and we'll give you an opinion as to whether we think it's worth it. Because federal court's a lot of work, it's not something that you got to show an error of analysis, not just a disagree. Rock is back. 15-year look back from the fact. 5-year, yes, 5-year look back. Any hearings that are done now, 5-year look back. Any cases that are done adjudicated after. Any case in process after June 26th, whenever it was, 5-year look back. Hey, Sharon, how long to waiting time? Sharon's one of my clients. That will be 5 or 6 months. We should get a hearing. That's usually the time. Regarding work history, 40 positions in one job. No, you won't. That is called a composite job, and you want to identify each part of it. And the vocational witness will call it a composite job and give different DOT numbers for each one. Elizabeth, good evening to you. Christina, don't forget to like, share. Thanks, Christina. I appreciate that. What is PC3? Don't know. What context? I don't know what that means, Matthew. What context? What does it mean I received a 20 form? This is just asking about work history. That's really what that's for. Jenny Joe, well, I appreciate you telling me I'm appreciated. Thank you very much. I only got about, let's do another 10 minutes and time for me to get my beauty sleep. So I'll kind of zip through some of these here. Had my hearing, the judge asked a lot of what if and hypotheticals. Vocational witness said 3 jobs. If I added a hypothetical, I would require every 2 hours. That's an interesting question, because one of those hypotheticals reflects what the judge is thinking. You just don't know which one. Hopefully it's the one where the judge felt like, that the medical evidence supported your argument that you had to recline every 2 hours. But we don't know that. So if that's what the judge assumes, that's what the judge accepts, then you win. If not, you lose, unfortunately. I had a hearing, it was on 11 ABC advocate only. This said 3 jobs. She made statements that were off for 3 days. Okay, so to summarize what I think you're asking here is, advocate, I think you mean the vocational witness. Many times the judge will ask a question with limitations, light work, no climbing ladders, ropes, and scaffolds, no kneeling, crouching, crawling, or stooping, no overhead reaching. Are there any jobs? The vocational witness will say, yes, there are jobs. The judge will say, thank you, no more questions. Mr. Attorney, do you have any questions? I'll say, Mr. Vocational Witness, if our hypothetical person was off task 15% of the day or more, would that allow for competitive work? No. Mr. Vocational Witness, if our hypothetical person would miss 2 or more days of work a month, would that allow for competitive work? No. The problem is the judge doesn't have to accept my question. So if the judge is using a hypothetical question as the basis of his finding of your residual functional capacity, your RFC, and it doesn't, and the answer to that question was there are jobs you could do, you're not going to win. The lawyer is always going to ask questions that have severe limitations that will disable you from all jobs. The problem is the lawyer's not the judge. So, you're doing that to perfect your record, but the reality is, the judge is going to decide which question he's going to use. Okay, past work can't reform more medical records. Okay. Lavinia Clark, hello, how are you? Okay, there's Garrett there. What advice do you have for supporting invisible illnesses like fibro and chronic fatigue and long COVID and blah, blah, blah? Not blah, 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 physical, mental. Just need to have a really, really good medical record. Gotta go to the doctor a lot, keep a diary. Just keep a diary of your symptoms. Talk about all the treatment you're doing, whether it's prescribed treatment, whether it's trying to get in better shape, water aerobics. Just, paint a picture of your life. And, get third-party statements from people who've observed the problems you're having. That could be helpful, but it's hard. They're just hard. Long COVID, they're going to be looking for breathing problems. They're going to be looking for heart issues. That's going to be I think, where they're going to be focusing on for long COVID. Thank you, Luana. I appreciate that very much. Deb, yeah, you can spend that money, get a 2,000. Okay, so I think Deb is telling us about SSI limitations. Doug, serious lymphedema in both legs, no medical history. Unfortunately, is there any way to get expedited approval? No, because there's no obvious condition. You need to go to the doctor. You need to have a doctor say, you have lymphedema and you got to keep your legs extended, or you have lymphedema, you're on diuretics and you've got to urinate every 35 minutes. Got it? You're not going to win. Judges can't just look at you and say, even an in-person hearing, oh, you're disabled. You got to have medical support. You got to go to the doctor. Lymphedema cases are good cases. I win a lot of them, but you got to go to the doctor. DD asking for my husband, approved in a hearing, not received notification. We're in Texas. If you got the hearing approval in writing, I'm not sure if you got anything or just the judge says you're going to get approved, or did you actually get a written favorable decision? If you did, the rest of it should be coming, but it could be they're backlogged and it could take several weeks, several months. So it's been about a month. I'm assuming you didn't get an ALJ favorable decision yet. That can take, anywhere from 4 to 8 weeks. So you're still within that period of time. It's not ridiculously long yet. The dude, get some rest. Yeah, I hear you. Okay. So Deb is just coming to somebody else there. Enjoy your vacation. Thank you, Joel. Yeah, I'm going to be, with lawyers like me, I don't really ever take total vacation. I'm going to be working a couple hours a day. I got my computer with me, answering emails. I've got a hearing I'm doing, get a little work done, do a little writing sometimes. But yeah, you got to refresh the batteries. So I'm going to really try to have a good time and see some things, or some, just walking on the beach is very relaxing if I can do it. Okay. Thanks for the knowledgeable videos, helping us, especially veterans. We appreciate you immensely. Thank you, Drexel. I really appreciate that. And thank you for your service. I appreciate that. 52, Lost Brooklyn, bilateral TMJ, failed surgery, limited opening mouth and creates chronic migraines. Yeah, I think that's a good case. I think you've got a pretty good argument. Failed surgery is usually a pretty good sign for a good argument. And headaches that would be logically arising from that. Yeah, I think so. Aoud, I had my hearing 2 weeks ago. Judge was waiting for physical therapy during the application. When his benefits, I improve a little now. So if the judge is needing more information, then that's usually a good sign that he's looking for a reason to approve you, I think. Billy Warehouse, 50. Already paid my 50 credits, I think you mean. Severe depression, anxiety, PTSD, fatty liver, pre-diabetic, arthritic. They denied you. Appeal. You want to appeal. That's not surprising. They would. I hear you, Tat. I did respond to you today, I believe, but by email. But Billy's going back to disc hernia. It just, appeal it. You want to appeal it. You definitely want to appeal Deb, 32. Dr. 32 is tough. 32 is tough. Do I take CDR cases? It's hard to take CDR cases because most people choose to have their benefits continue while you are fighting the CDR. Means there's no past due benefits. I don't take a lot of them just because, most people either can't pay for it out of pocket. Also, 47 is tough. I mean, I look at them one case by case. I've got a few right now, but most of my cases are people applying for benefits the first time. So I'm very selective, but if I can't do it, I'll get you to somebody who can, but I don't take a lot of them just because, again, there's just a lot of new stuff that I'm dealing with mostly. Rod Jameson, 58, rent-free consideration. How long does the decision take? I think we answered that. That's going to be probably anywhere from, 6 to 12 months. Thanks for invitation. Thanks for us. Okay. And St. Louis, no offense taken. I'm not offended, but I mean, it's important for you to know. I mean, I'm not in any way, shape, or form intimidated by a judge. I mean, I'm too old for that. When you get to a certain age, you're like, judges are people, and you treat them the way you want to be treated. And I think if you go into a hearing, certainly as an attorney, and I will tell you, as a young attorney, you can get intimidated by judges, and there were judges who like to throw their weight around. And when I first did this years and years ago, there were a couple of judges I later became friendly with who did that to me. They just were like, I'm going to show you who's boss here. And many that didn't, but some did. And, you get to a certain point, like, I've done this for a long time. I know what I'm doing. I've probably done it longer than the judge. And yes, I'm an advocate for my client, but no, you're not going to push me around. If I have an argument, if you don't agree with my argument, fine, you can deny my case, but I'm not going to, just back off. I know my case, and I'm going to make my argument, and that's just what you got to do, and I think that I've had cases where I've had judges challenge me in a respectful way, and I push them right back. I had one judge, I remember, in a case out of Texas, never forget, I never had him since, but he was like, well, I want you to amend the onset date. I'm like, no, I'm not going to do it because there's no reason to. And we bent back and forth for 45 minutes. Finally, he's like, okay, I agree. You win. And, it wasn't like I was being mean. I knew my case. So you got to do it. Budapest, Hungary. Nice. I've had cases out of Vietnam, but never Budapest. I've heard it's beautiful. Actually, a friend of mine was just there this last week, posted some pictures on Facebook. It looked really, really nice. I've heard it's really nice there. But I've never been. Let's see. D.D. Johnson, another channel I'm on. A person in Texas was approved in March, is still waiting for official approval letter. They are backlogged. Yes, they are backlogged very badly. Texas especially. Look, I think we've answered that. John, I'm not sure what John Boy's asking here. Bank account is a bonus. Opening bonus, that's not in. No, that's not income. That's not income. David, John, you are welcome. Tracy says, Deb, praise for permission to medicine. Right, I agree. I feel the same way. You've been through a lot, Tracy. I hope nothing but the best for you. Excuse me. When you drink these carbonated drinks. Water. Jim from Michigan, just want to thank you for taking my case. Okay, Jim, I know we are trying to get SSA access. So we will do my best. I'm doing my best trying to get SA. I know Jen's been working on that today. We're working on it. We'll try to get access so we can not have to postpone. Martin, can I qualify? Again, if you're on workers' comp, you may qualify, but you're not going to get any money until the comp case settles. If you have a stroke, I think we speak today or we emailed today, maybe. But anyway, the stroke could disable you if it's going to keep you out for a year. Rod, 6 adjudicator. Yeah, it's bad. I mean, you're the one maybe in Texas. It's bad. This is where you contact your congressperson and say, hey, we got a problem here. It's been way too long. Thank you, Tracy. I appreciate it, and good health to you. Thank you very much. Spinal narrowing with osteoarthritis. We're going to get close to the end here. with osteoarthritis and can't stand more than an hour. Can I get SSDI? Very possibly. That looks like a grid rule case to me. I think you've got a real good shot at the grid rule case based on that. Okay. If working on disability cash, I don't understand the question. If you're working, can you get cash app money if you go over your limit? I don't know what that means. Hearing successful, back pay, normally it's about anywhere from after you win, it's going to be about 6 weeks, 4 to 6 weeks before you see any money. 51, diagnosed with 9 mental and physical illnesses. They denied you on reconsideration. Again, it depends on how severe they are, Billy. I just don't know what the issues are, but it just depends on how severe they are. And how well documented they are as well. Do I have many nurses? Actually, I do. I have a lot of nurses, a lot of CNAs, a lot of nurses. It can be a very physical profession. It can be very stressful. And it can, it's both physical and emotionally and psychologically stressful. I probably have represented 50 nurses over the years, so it's not at all uncommon. Not at all uncommon. In fact, I've had a couple of really good fibro cases. I don't do a lot of fibromyalgia cases, but I've had a couple of nurses. I remember one lady, this is probably 15, 20 years ago, an ER nurse with fibromyalgia, and it was totally legitimate, and we got her approved. Because just, nursing is a calling, like teaching. Nursing is a calling, and nurses don't stop working because they're hoping to get some money from Social Security. They want to do their job. So yeah, I get to see a lot of them. It apparently so. I don't know again what the, but yeah, if you got it quickly, that's cool. That's cool. When they look at your past work, yes, it will. It will look at that 5-year look back. Okay, I'm going to have a couple more questions. Counselor, the judge asked questions of vocational witness. I can do 3 jobs. I still won. Again, the judge can decide, maybe your attorney asked more questions. The judge asked other questions. The judge decided to disregard the vocational witness. So it can happen. So that's unusual, but it can happen. Do we pay taxes? Again, look that up. Look that up. If you just type in taxes and Social Security, okay, Jim, I'm going to check. If we got it, I will definitely check tomorrow. Okay, we got to 2 more. I'm gonna be done. Lionel, I just got denied initial app. They said they look at my doing doctors. They should ignore my medical evidence. I can protect this in consideration. Well, first of all, you make sure that they got it, and you can't force them to read it, but it's got to be in the file. And certainly, when you apply for reconsideration, make sure that you reference what the doctor said. But when I don't know that they said they didn't look at it. But again, they will tell you in the denial notice what they looked at. So if it's not there, that means it's not in the file. And so I think you want to make sure that you get it in the file, either by having your lawyer submit it or you submit it to make sure they've got it in the file. Okay. I have an open case, started with workers' comp, came out of the workers' comp with impairment of 15% disability only after I went through the whole process. Not sure if I understand what you mean by that. If you settled your case and you got a settlement that says that your benefits, your lump sums will be paid over your lifetime, the 50% disability rating is not going to really mean anything in Social Security. You've got to show you can't do anything at all. So the workers' comp is simply a part of that. It's part of your record, but it's not going to be controlling on anything. Okay. Rod, you are very, very welcome. Okay. I'm going to have to end it here now. We have been going on for 2 hours and 13 minutes. So I'll be on next week from the Isle Palms. So I hope I have a good internet connection. If for some reason I don't, I'll let everybody know, but I'll be available by email certainly, and the staff, my office is still open. So if you need us, please reach out to us. Again, please leave me a review. I would really appreciate that. And I'll put this down here as well, that if you need a case evaluation, please contact me at contact Jonathan 3 as it says in the crawl there, and we'll be happy to take a look at it. So I really appreciate everybody being on. I think there are over 150 people watched us tonight. I'm trying to get that closer to 200, just because we're trying to grow it. So if you know anybody who might find this of value, please let them know to tune in. And I will hope everybody has a great week, and I will see you next Wednesday. So good night, everybody.